Thank you all for coming and welcome to UTRF's Patent Essentials Seminar, which is given by one of our law firms that we work with, Kenyon & Kenyon. It is my pleasure to introduce to you all John Hutchins, Dan Shanley, and Adil. We do a lot of work with them and we hope to continue to do more. So with that, I'll turn the stage over to John.
Thank you so much. And music to my ears on the more work. My name's John Hutchins, and first let me thank UTRF and the College of Engineering, and it's wonderful to be here, and these facilities at Minkow are amazing, so thank you very much. I've been practicing patent law for about 20 years, litigating primarily patent cases, trying patent cases and licensing patents. And if there's any doubt that I've been doing this for 20 years, compare the young, fresh-faced lawyer in my ancient marketing photo with the grizzled veteran you see here, and you'll see what 20 years of patent litigation will do to a person. We were provided a list of questions and topics that we thought might be of interest to you and to UTRF in the university setting. That we're going to be going through today. And then there'll be time for questions afterwards. Some of you are maybe familiar with a lot of this material. You may have patents, others not. So I'll try to hit a happy medium with what we talk about in the level of detail. But if you want to discuss anything in more detail afterwards, please feel free to ask questions and we can discuss it either in the group or separately. We're going to start by talking about some of the basics, what a patent is, what it allows you to do, what it is not. And then we're going to talk about inventorship. And in the patent law, what that means, what that describes, and the rights that inventors have in patents. And also when you have multiple inventors, how that works and the rights that they have. Hopefully this will help you understand as you're working on your inventions who is and isn't an inventor and what effect that might have. Then we're going to talk a little bit about what is patentable. The things that can be patented, as you can imagine, are varied. But we will talk about a few limitations on subject matter for patentability. There's not many. Just about anything under the sun is supposed to be patentable, and the system is set up that way on purpose because there's no limits to the creativity of people. There's literally 7-8 million patents at this point just in the United States. So we want there to be a very broad array of technologies and ideas that can be patented. Then we're going to talk about what it means for your idea, your invention to be new or novel and non-obvious. Because if your idea isn't new and if your idea is obvious, well, common sense would tell you that we shouldn't be issuing patents on those because they're not by definition particularly inventive. On the novelty front, what I'm going to be focusing on is what constitutes a public disclosure of your idea, because it is critical that people who are inventors understand that disclosures they make of their own work can harm their ability to patent and protect that work. And at times it is crucial that you disclose your ideas to, for instance, the UTRF patent associates before any disclosure of it occurs, so that you can properly protect and get a patent, for instance, on your ideas. So that's what we're going to be focusing on for novelty purposes. And then I'm going to talk a little bit about what it means for an idea to be obvious. Because while we all have a lay understanding of what something is that's obvious, that has a particular meaning in patent law. And it's the standard by which the patent office will look at your invention when they're deciding whether to issue a patent or not. Everything I'm going to be telling you about is the law currently. The law changed a change in the law went into effect a couple of years ago. So for those of you who have patents that are still in the system from a couple of years ago, a different law may be applying on some of this stuff. But I'll highlight just a couple of the recent changes in U.S. patent law. And then my partner, Dan Shanley, is going to describe the types of patent applications that you may be applying for, and discussing the thought process that goes into determining what type of application you'll want to file, and some of the details on the process of obtaining a patent and things then such as the costs and timeline. And we'll talk a little bit about getting international protection for your ideas as well. Okay, first on a very basic level, I have a chart here you can look at that simply distinguishes patent protection from other types of common intellectual property protection such as copyrights or trademarks. Patents protect useful, new, and non-obvious ideas or inventions that you have. And there's things called design patents we'll be talking about that protect new, original ornamental designs, how a product looks. The most famous of these, perhaps, is some of Apple's design patents. If for no other reason than they won like $1 billion last year on their design patents. So design patents certainly can have some value. The key with patents is the right does not adhere naturally to your work. It does not arise automatically. You have to take particular specific activities in applying for a patent application before the government will give you any patent rights. That's true no matter how good your idea is. Not so with copyrights or trademarks. Copyrights protect any sort of tangible creative expression, most commonly works of authorship such as novels, but it could be any type of writing, movies, sculptures, paintings, products that have a particular shape. Anything like that can be subject to copyright protection. Copyrights, though, adhere automatically. As soon as you create the work of authorship, you have copyright protection in that, regardless of whether you register it with the government, although you should, because there are definite benefits to doing so, that particularly if you want to try to enforce them. We're not going to talk about that, but the fundamental right will adhere automatically. Trademarks deal with a different type of intellectual property and a different concern. The goal of the patent system is to reward and promote inventive activity. The goal of trademark is to prevent confusion in the marketplace generally, particularly with respect to the source of goods. So trademarks will protect your business's name, words, slogans, logos, anything particular to your business or their products that associates those products with your particular company in commerce. And those rights accrue simply by virtue of a business using the trademark and using it consistently enough so that people will associate the logo or the slogan or the mark with the business. And when that occurs, you are entitled to trademark protection. Again, that's true regardless of whether you register your trademarks, but please register your trademarks because there's benefits that are very real to doing so. But they're not fundamental to the right, like with a patent, where you absolutely have to apply for a patent in order to get the right. So what is a patent? Well, there's a give and a take with a patent with respect to the inventor and the government. The purpose of having a patent system is so that people, and inventors particularly, will publicize their inventions. Why is that beneficial societally? So that other people can read the patents and learn about the invention and hopefully improve upon it. To promote this, however, inventors need to be given a reward for letting their secret inventions be known. So what is that reward? Well, the government will give you 20 years of exclusivity on your claimed invention. So you say, I'm willing to make my idea public, hopefully to benefit the public, but in return I get a pretty long period where I get to prevent anyone else from using my idea. Now, once the patent issues, the government isn't going to step in and make sure that nobody is infringing upon your rights. You have to take those actions. So it's not the government that enforces patents, it's the individual patent holders who have to take actions to enforce their patents. Now, a common misconception: simply because you've patented an idea does not necessarily give you the right to practice that idea. Because there may be something called a blocking patent where somebody else has already patented a portion of your idea, and you would need their permission before you actually practice what you've invented. So there's a difference between being able to prevent others from using your invention and being able to use it yourself. Here's a very simple example, so simple a caveman can understand it, but way back when someone thought of a bucket as a good idea to get water from the river to wherever they live. And so the first person got a patent, assuming one existed in this time frame, on a bucket. Caveman 2 shows up and says, you know, I can only carry one bucket at a time and it's bugging me. If we slap a handle on that bucket, I can carry 2 at a time. That is a wonderful idea and indeed an improvement on the bucket concept. Caveman B would need Caveman A's permission to go to Rubbermaid at the time and sell handled buckets, because Caveman A controls the patent on all buckets. So Caveman A's patent blocks Caveman B. That said, Caveman A can't sell a bucket with a handle without Caveman B's permission. So that's the fundamental concept that we're talking about with what rights you get with a patent. There are limitations on these rights. 20 years from the time you file your patent application, it will expire, and then the public can do whatever they want with it. And of course, as I mentioned, that's the quid pro quo. That may be extended a tiny bit of time if the patent office was dilatory in getting your application through, but generally 20 years from the date you file your application is when it expires. And U.S. patent rights control activity within the United States. So if you have a patent, a U.S. patent, you can prevent others from making, using, selling, offering for sale, or importing your claimed invention in the United States. If someone's undertaking activity in France entirely, your US patent will have no impact on that. You would have to get a French patent. Why are we even here talking about patents, and why do they matter? Well, the short answer is money. Patents can be very valuable, and oftentimes people are willing to pay a lot of money to get these exclusive rights. UTRF is among the world's top universities for getting utility patents. They were 80th ahead of Emory, Yale, and those slouches at Princeton. And to give you a sense of the dollar amounts that can be at issue, I've already mentioned Apple and their massive, massive case against Samsung. A client of mine had a patent and it was involved, had licensed a patent with Wake Forest University, and they stopped paying royalties on that patent, and there were hundreds of millions of dollars at stake. Wake Forest was receiving a lot of royalties on this patent portfolio. This dispute was written up in Fortune magazine, among other places, but it would give you a sense of the types of dollars we're talking about here. And below you see, can be literally billions of dollars in revenue to major universities from licensing activities for the patents of the people who are inventing at those universities. So it is absolutely crucial that everybody do what they can to make sure that those rights are protected. Okay, let's talk a little bit about what it means to be an inventor as you're going about in your laboratories doing the work that you do. When we talk about invention and who is an inventor, it depends upon the meaning of conception, because an inventor is someone who contributes to the conception of a claimed invention. Now, when I talk about a claimed invention, if you're at all familiar with patents, you'll see at the end of the patent, and that we have an actual patent in our handouts, there's a list of numbered claims, and those claims are like a property deed. They describe with particularity the exact invention that you are claiming is yours, and they define the rights of exclusion that we've talked about. So an inventor is anyone who contributes to the conception of those ideas as they're specifically claimed in a patent. And conception is a legal concept here, and it means the formation in the mind of an inventor. This is the mental aspect of invention. The formation in the mind of a definite and complete idea of the invention as a whole. Once that happens, the invention is done as far as the patent law is concerned. Now, it may eventually have to be built into a physical form, but that is not required for invention. And so if you have a complete idea in your head of an invention, even if someone else actually builds it at your instruction, that person is generally not an inventor because they didn't contribute to the conception of the idea. Similarly, the people who pay for your lab aren't inventors. They're your sponsors or your backers or the people who give you grant money. They're not inventors. So we're focusing on who actually came up with the idea. Now, some ideas are contributed to by a lot of different people, and so you have joint inventors. Patents can have lots of claims at the end of them, and usually 20, because that's how much you get for your upfront fee, without having to pay additional money. Every person who contributed to the conception of any claim has to be listed as an inventor for that patent. So there could be 20 claims, and one person invented 19 of the inventions in the first 19 claims, and one person contributed in part to the 20th claim. They are both equal co-inventors of that patent. Why is this important? Because co-inventors, joint inventors of a patent, each can independently assign or license that patent without the permission of the other co-inventors. So even though someone may have contributed only a part of one claim, they can turn around and sell the patent in its entirety to Apple. And there's nothing you can do about it to stop them. Unless you contractually agree in advance what's going to happen with those rights. And that's normally what happens. Now, two people can be considered joint inventors even if they actually don't work hand in hand together. You don't have to be working together in the same location. You don't have to be working together at the same time. But as long as either of you have contributed something of meaning to the claimed invention, you're entitled to be a joint inventor. And the contributions don't have to be equal, as I said. They just have to be a real contribution. Now, here in the university setting, if you're doing research work at the university as a professor, for instance, UTRF, University of Tennessee and UTRF have a patent policy that will control who owns those patent rights. So when I'm talking about inventors getting these patent rights, again, I'm assuming that they weren't contractually obligated already to give those rights to someone else. Certainly in an employment context with a private company, if you work for Intel, it's very clear to those workers that if they come up with something inventive, they don't own those patent rights. Those rights go to Intel. Similarly, here at the university, when you have an idea and you disclose it to UTRF, UTRF and the university will decide the ownership of those rights. But fundamentally, as a matter of strict patent law, the inventors are entitled to those rights. And it is important that you properly describe who's an inventor. Because if you do not properly describe who's an inventor, you can lose your patent rights. They can be unenforceable. So if you're in that position where you've done nearly all the work on all the claims and there's one other person on one claim who contributed a little bit, if you don't want him to have those rights, you can't just leave him off the application. The way to solve that is to file two applications, one with just your ideas and then you're the sole inventor, and the other with the joint ideas, and then you'd be co-inventors on that patent. All right, let's talk a little bit about what can be patentable. There are three things we're going to be talking about: the basic subject matter of what's patentable or not, and then what it means for an idea to be new and non-obviousness. Non-obviousness and novelty are also required. This is just a reference to the provision in the Patent Act that describes the types of things that can be invented. These are somewhat archaic terms, but the bottom line is just about any device, system, apparatus, method of doing something, process, anything you make, any composition of matter is eligible subject matter. We want this to generally be as broad as possible, but there are exceptions. The main exceptions that we talk about, and these are overlapping categories, that cannot be patented are because the legal system and judges have sort of determined that it would actually be bad for society if we precluded people from claiming as their own certain things that still may be useful and inventive. Abstract ideas, basic economic theories or methods of doing business, and this would include methods of doing business now using the internet or using a computer. And so you may run an auction house, and if you come up with, say, hey, you know, if I run my auction house over the internet and think of how much more efficiently it will go, and I'll have more buyers and more sellers and everything will work better, you're not going to be able to get a patent on that because that's going to be considered too abstract. And the mere fact that you're taking this abstract idea of how to do business and in a way using computers to help you with that does not turn it into a patentable invention. Natural phenomena cannot be patented. Certainly humans can't be patented, but further discovering new plants that already exist. When Darwin went to the Galapagos Islands, he made amazing new discoveries, but those new plants and species he discovered already existed in nature before he got there, and he wouldn't be entitled to patents on them. A more modern example would be people have discovered that particular gene sequences have great utility and can be very important because they can be indicators, for instance, of a person's likelihood of having certain types of cancer. Despite the value and usefulness of those discoveries, you cannot get a patent on an isolated gene sequence because that gene sequence already exists in people walking around. That's considered a natural phenomenon that cannot be patented. Now, you can take that gene sequence and modify it and get a patent. You can use that gene sequence to come up with a marker or a test for cancer, and that test for cancer may well be patentable. But the gene itself, you cannot get a patent on. And similarly, laws of nature, basic mathematical formula, things like that cannot be patented. Now let's talk about what it means for a patent to be novel. When you try to get a patent, your idea is compared against everything that came before you filed your patent application. The phrase we use to describe everything that came before your patent application that was public, and we'll talk about that, is called prior art. So if you hear prior art, the prior art for each patent is different because it depends upon when that patent was filed. But prior art generally refers to all of the public stuff that occurred before you showed up at the patent office and said, hello, please give me a patent. Now generally, and this is very important to understand, once an idea has been disclosed, and this can be disclosed anywhere in the world, on the other side of the globe, if your idea has been publicly disclosed before you show up at the patent office with your application, regardless of when you thought of your idea, you will be prevented from getting a patent. And this can include disclosures you yourself make. Your own work can be used against you as prior art and can prevent you from getting a patent. What does this mean? It is very, very important that you get your ideas to the patent office as quickly as possible without first disclosing them so that they can be protected. And the people at UTRF and the licensing associates are here to help you do that. But you have to cooperate with them and disclose your ideas to them before you disclose them to anyone else. Okay. What counts as a public disclosure? Just about anything, if it's public. And it doesn't have to be to a lot of people. You could disclose something to a handful of people. If I made a disclosure in this room right now to all of you, that could prevent me from getting a patent at the patent office on that idea, because this would be enough of a public disclosure. Certainly any published patent applications count. Publications, and it doesn't have to be in a fancy journal. Any publications, posters, abstracts, dissertations, grant proposals, public uses of your idea, simply showing it to people can prevent you from getting a patent. Now, there's an exception for that for purely experimental uses, because you are allowed to work on your invention and experiment on it to see that it works as intended. And so there is some exception to that, but generally any public use is considered prior art. Same thing for any commercial use if you're selling something. And then there's a catch-all, anything available to the public. So this is very broad. So you have to know as you are working on your research to make sure that it is not being disclosed, and you may be disclosing it without even realizing it if you're not careful. Now, in the United States, and I'll stop there because this is largely only in the United States, there is some grace period that I'm going to talk about. But don't rely on this because you'll still lose your worldwide rights. So if you ever want to get a patent in Japan, for instance, you're going to want to make no disclosure whatsoever before you file your application. But in the US, if you do disclose your work before filing it at the patent office, you will get a 1-year grace period to file your application. So if a disclosure is made by you within a year, or it's made by someone else who got the idea from you, so you intended to keep it secret, but someone else blabbed, that's not going to be held against you for this year grace period. You can file your application and get a patent within a year. But that's the US only, and it's a limited exception. Here's a very simple example. You file your patent application. Prior to that, someone else disclosed your idea anywhere in the world, no patent, even if it was the day before. And it doesn't matter when you invented. Here, you make the disclosure. If it's within the year, you can get a patent. And here's another little wrinkle. If you make the disclosure within the year, and then someone else independently makes the same disclosure, that will not bar you from getting a patent. But it has to be the same disclosure. If they disclose something that's similar but different, that will be held against you. But if it's the same disclosure by someone else, you'll be okay provided you first disclosed. So this is for the situation, say you make a disclosure at a meeting. If someone else, well then it would be derived, but if someone else then makes a disclosure a week later, that won't be held against you. In general, though, you want to avoid any of that hassle by disclosing your ideas first to the UTRF associates so they can get a patent application on file. All right. In addition to not having been disclosed before exactly, your idea has to be not obvious in light of the prior art. So let's talk about what it means for your patent claims to be considered obvious. And here we're talking about the invention as a whole. And the patent office will look at your claimed invention as a whole and try to come to a determination of whether it's obvious in light of everything that came before. So what are we talking about here? Well, obvious to whom? The determination of whether something is obvious isn't whether it was obvious to the inventor, because inventors are exceptionally smart, creative people, and things that are obvious to them are not obvious to other people. That's what makes them inventors. The question is whether it's obvious to an ordinarily skilled person in the art to which the invention pertains. And this ordinarily skilled person isn't an actual guy sitting somewhere at UT. It's a hypothetical person, it's a legal construct that we use to figure out whether something would be obvious. So you have to figure out what's the level of skill in the art. In certain arts, it's extremely high level. Could be a PhD who's worked for 5 years in certain biotechnology or pharmaceutical applications. I do a lot of work in the toy industry. In the toy industry, a person of ordinary skill in the art could basically be a layperson, you or I. And very simple toy ideas will be judged whether they're obvious to ordinary people in the lay sense. But it varies from field to field. When is this determination made? It's the time you file your patent application. So if you're asserting a patent years later, 10 years after you file your application, obviously the industry may have changed, the state of the art has changed. The determination isn't whether the idea is obvious at the time you're asserting your patent, it's whether it was obvious at the time you filed for your patent. And that's only fair because things that came later shouldn't be held against you. And why is it obvious? And this is particularly important because in retrospect, in hindsight, many things appear obvious that really weren't at the time. Everybody knows that if you put electricity through a filament of metal, it will heat up. And people know that as metal heats up, it emits light. And people know that a filament that's hot will deteriorate if oxidation occurs. So it should have been obvious that if you run a current through a filament of metal, in a vacuum, you can get a sustained source of light. But that doesn't mean that Thomas Edison wasn't entitled to his patent on the light bulb. So there are very novel and creative and non-obvious ideas that once someone thinks of them, everyone says, oh, of course. And we have to fight against that bias when we're determining whether an invention really was obvious. So you have to find in the prior art a motivation to have arranged the prior art in such a way as to arrive at the invention. And you're not allowed to cheat by using the invention itself, because that's not fair. This is called motivation to combine. So if you hear motivation to combine, that's what we're talking about. So how is obviousness determined? Well, sort of just how I described. You look at what's in the prior art. You say, okay, how is that different than your idea? What's the level of ordinary skill in the art? And then you say, okay, comparing the invention to what was in the art before, through the eyes of this hypothetical person of ordinary skill, would it have been obvious? Things that are obvious. If you're assembling known components and they are continuing to operate exactly in the way that you would expect to achieve the result that you would expect, that's obvious. You can't take two things, put them in the same housing together, and they're operating in the same fashion, but now they're joined together and say, oh, that's not obvious. Substituting elements that are known to be interchangeable, obvious. If there are a limited number, a relatively small, finite number of ways of doing something, if you try each of those ways and happen across one you like, obvious. And that often happens in the pharmaceutical area, where there may be a drug that uses a particular salt. And there's a relatively small group of associated salts that one would expect, if you were a chemist, to have similar results. And so you try all 35 salts, here 53 salts, and you pick one you like. You can't get a patent on just that particular salt, even if no one else had ever tried it before, because you simply got the result that one would have expected. However, if you get unpredictable results, better results than were expected, synergy, if you will, that's not obvious. If the prior art taught away from doing what you did, you were going against the grain, not obvious. If you use an item from one field in a way that wouldn't have worked in that field, but works in another, not obvious. And it's not fair at that point for the patent office to say, oh, well, you could have just changed it in the way you did and anyone would have thought to do that. Well, no, because it wouldn't have worked in that field in that way. It's only in the new field when I made that change that it worked. As I mentioned, there's a trap with obvious because people want to look at things with hindsight and say, I could have thought of that. So people who are defending their inventions against a charge of obviousness are allowed to look at things that occurred in the real world after they had their idea that may indicate it wasn't so obvious after all. These real-world considerations are called secondary considerations of non-obviousness. And this is not rocket science. These are common sense ideas. I already mentioned unexpected results. If you come up with an idea and start selling a product that embodies that idea and you're making millions of dollars, that's an indication that your idea was not obvious. Because if it was so obvious, wouldn't someone else have wanted to make that money? I know I would have. If other people tried for a decade to solve the problem you solved and couldn't, that failure of other people is evidence that your idea is not obvious. If you came out with your idea and that jerk down the hall from you made fun of you for it and said that's not going to work, aside from indicating he's not particularly supportive, it actually ironically may help you by being evidence that your idea wasn't obvious. Alternatively, if the nicer people down the hall say, wow, what a great idea, and praise you for it, that's an indication of non-obviousness. And if you're trying to get a patent, you can put in this type of evidence, or if you find yourself in court defending your patent, you can put in this type of evidence to try to show that your idea wasn't obvious. Okay, as I mentioned, everything I discussed is the law as it currently stands. The law changed a couple years ago, when the changes went into effect a couple years ago in large part. So as of March 16th, 2013, any applications filed after that, and certainly any patent applications filed today, are as I described them. If you have applications that are pending from prior to that time, some of what I said wouldn't apply. But the America Invents Act was a reform to the Patent Act, and the main changes I just want to highlight are one, we're now a first-to-file system. So prior art is largely considered prior art because it occurred before you filed your patent application. And that is true regardless of when you actually conceived your idea. It used to be you file your patent application and the patent examiner would say, I found your idea from 6 months ago, so I cannot give you a patent. You would then go to the patent office and say, you know what? I thought of the idea 9 months ago. And here's my lab notebook. And since I conceived the idea 3 months before this guy, give me my patent. And the patent examiner would have said, yes, okay. Because you had thought of the idea first. That is now out the window. Now, if you said, but I invented it 3 months earlier than this guy disclosed it, he would say, gee, that's a shame. If only you had filed a patent application through your UTRF representative, I could help you. But you didn't, so I can't, so no patent. And as I mentioned, prior art is prior art if it was publicly disclosed anywhere in the world. And that's a change in the law. The other important change in the law is that they've created a number of procedures at the patent office to attack patents once they have actually issued. And this is an alternative to very expensive patent litigation. And so if a patent is asserted against you, you can go to the patent office with your prior art and tell the patent office they made a mistake, and they will possibly reopen the prosecution and look and determine whether they did in fact make a mistake. And people have had great success in validating patents using these processes in the last year or two. And so they've become very, very popular because they're much cheaper than fighting it out in court. Okay. Because we want to keep the videotape the same, I'm going to take questions at the very end of the presentation. But now my partner Dan Shanley is going to talk to you a little bit about the process of obtaining an application from the Patent Office and the types of applications that you can get. Okay.
Okay, well, hello, everybody. My name is Dan Shanley, and John does patent litigation and licensing. What I do is I do patent prosecution. Patent prosecution is the back and forth between the Patent Office and an outside attorney. Also, it deals with preparing and filing patent applications. I went to law school at night, and while I was going to law school, I was a patent examiner at the U.S. Patent Office for around 5.5 years. And so I've been in private practice at law firms for the last 10. So I know John covered a lot of material, so you're probably, where are we in the presentation? We're well into it. If this were a Lady Vols basketball game, we'd probably be about midway through the second half with UT hopefully up by 20. So I'm going to try to run through this material as quickly as possible. I'm not going to hit every bullet point. I will just kind of go over the highlights of the presentation, and then this is intended to be kind of a desk resource that you can keep in your desk and at a later date possibly refer to it if you had any questions regarding the patent process. So again, I'm going to talk today about types of patents, patent applications, and then I'm going to give you an overview of the patent process. If you were an inventor in the College of Engineering here at University of Tennessee and you submitted an invention disclosure to UTRF. So that brings us to the first slide, and these are the types of patent applications. There's 5 types of patent applications. There's design patent applications, there's provisional patent applications, there's U.S. utility applications, there's PCT or international patent applications, and there's plant applications. We're going to discuss the first 4 today, but we're not going to discuss the 5th, which is plant patent applications, which you should know they can mature into plant patents, but they're probably not appropriate to discuss here today with the College of Engineering. That would be more appropriately discussed with a separate presentation to the Agricultural Institute here at UT. So that brings us to our first type of patent, that's design patents. What are design patents? John referenced them earlier. They protect new original ornamental designs for article manufacture. In a nutshell, what does that mean? It means that design patents protect the look and feel of a particular article manufacture or product. So the first example, there's an example here we provided, and this actually is, it's the design patent 677. It issued to Apple in 2010, and it was actually a design patent that was used and asserted against Samsung. And that was part of the billion-dollar judgment that John referred to earlier. But this particular drawing is a good illustration of what a design patent is. A design patent, this design patent covers only the screen, the black screen on the front of an iPhone. So it's basically just a flat black screen with 4 curved corners. This is what this design patent is directed to. Also, there's some other ornamental features that I could point out in the design patent. You see the circular button at the bottom. This also could have been the subject of a separate design patent. Also, the longitudinal slit at the top, which is the speaker on an iPhone, as you all know, that also could have separately been the subject of a design patent. So you could have had possibly at least 3 design patent applications for this particular product, and I'm sure Apple did. What are some of the benefits of design applications? They're easy to get. If you go through the Patent Office, the prosecution process at the Patent Office, you rarely get a rejection for design patents. What does that mean is if you file a design patent, it takes about 6 months to a year. There's usually no rejection, and it ultimately ends in the issuance of a design patent within 1 year. So there's certain industries that like design patents, industries with short shelf lives for products. Electronics industries use them a lot. Apparel and footwear. Nike is a prolific filer of design patents. Also, the automotive industry also is a big filer for design patents. Some other benefits of design patents is that they're cheap to prepare. Design patents, there's really no claim. There is one short claim, but there isn't a lot of, that's not what decides the protection of the patent. In a design patent, it's basically comes down to the drawings. So your drawings are what covers the invention. So the only cost associated with preparing a design application is the preparation of the drawings themselves. And then there's minimal time by an outside attorney, maybe an hour or two, to put together the paperwork and file the design application. Design applications run 14 years from the date of issuance of the design patent. That's actually going to change in May 13th, 2015, when the U.S. is part of the Hague system. All that means is that that an additional year will be added on. So it will no longer be 14 years from the date of issuance, it will be 15 years. There are drawbacks to design patents. There's only minimal protection. So let's take the one with the circular button at the bottom. All Samsung has to do to avoid this design patent is to make that button a square, right? So there's minimal protection on the design patent. Therefore, the strategy is usually to file a lot of them, or it just gives you a leg to stand on in case of knockoff. So that's where they're really used in the consumer product industry. The next type of patent application we're going to discuss, which does not mature into a patent, is a provisional patent application. A provisional patent application serves as a placeholder to later file a utility patent application. So a good example where a provisional application would be recommended, such as by a licensing associate at UTRF, is you're an inventor in the College of Engineering, you could be a professor. You have a really busy schedule, you didn't get around to filling out an invention disclosure form, and you do, but you do 2 weeks before you're about to give a presentation in, say, Colorado. Okay, so during that presentation, you have some of the patentable subject matter that should be the subject of a utility application, but there's not enough time to prepare a utility application in 2 weeks. So what does the licensing associate at UTRF recommend? Filing a provisional application. What they would do is they fill out a cover sheet for filing at the United States Patent Office. They'd probably put it onto your presentation, augment your presentation a little bit, possibly add some claims or a drawing, and file it as quickly as possible at the Patent Office. What this would do, again, is serve as a placeholder for you later, and within 1 year later from the filing date of the provisional application, to file what we call a utility patent application. So in a nutshell, provisional patent applications are placeholders for later filing a utility application. So utility patent applications and utility patents, what do? They protect new, useful, and non-obvious systems, methods, and apparatus. In some, they protect structural and functional features of a product. So let's move back to the iPhone example, where the button and the longitudinal speaker slot in the front face screen, those are ornamental features covered by the design patent. Okay, the utility patent, in contrast, would cover the inner workings of the phone, the hardware and software within the phone. So you'd also have several applications or patents directed to the inner workings, the hardware and the software within the phone. Okay, that's what the utility patent covers, where the design patent merely covers those ornamental features, again, the button and the longitudinal speaker slit. Design patents have several claims, usually about 20, because that's what's included in the USPTO filing fee. Remember, design patents run 14 years from the date of issuance. In contrast, utility patents run 20 years from the date of filing of the application itself. We'll look at another example, utility patent applications. Again, they can claim priority back to what we call the provisional patent application. So let's look at an example of a US patent. This is the 422 patent that issued in 2013. Mary Koshin, who's in the audience, is listed as an inventor on this patent. We've also provided that as a handout if if you wanted to see the full text of the patent. But for purposes of this lecture, we're just going to look at the first page. So it's got a lot of information on the first page. As you can see, it lists the inventor information. Then if you do move down to the next number there, it says assignees. So this shows that this particular patent was co-assigned to Siemens Medical Solutions and the University of Tennessee Research Foundation. So there's a lot of useful information on the front of the patent. Also, they have what's called an abstract. The abstract just gives you a basic overview of the details of the patent. So in this case, it tells you that this patent is directed to scintillator materials. Now, this is a good illustration, this patent here, because if you can see, there was a provisional application that was filed on this case on September 26, 2008. Okay, so when they filed, so for whatever reason, the licensing associate in this particular case recommended that a provisional application be filed in this case. That gave them 1 year later to file a utility patent application. So then you can see that a utility application was filed on September 28th, 2009. Now, there's a 2-day discrepancy, which I realize, and the reason for this is that the 1 year date from the provisional application, which would be September 26, 2009, was most likely a Saturday. Okay, so if the 1 year date falls on a weekend, then you get to the next business day to file the utility application. So this was timely filed within 1 year, but it was most likely filed September 28, 2009 was a Monday. So it was the next business day. Again, this application was timely filed. Utility application was timely filed 1 year after the filing of the provisional application. Okay, what kind of factors does a licensing associate look at when they're deciding whether to file a utility or a provisional application? We've already given you one example. A professor is going to give a presentation in 2 weeks, and it just comes to the attention of the licensing associate, and in that case, there's just not enough time to prepare a utility application, so the licensing associate at UTRF will say, okay, let's file a provisional application, keep it as a placeholder, and then we'll later file the utility application. The next two bullets kind of run hand in hand. That's the progress of the invention and the uncertainty, the importance of the invention. I think a good example here would be that the invention's 99% complete, or 90% complete, and remember we're in the first to file system, so in order to lock in the date, the licensing associate will say, okay, why don't we file this application now? And what we're waiting on, I guess to just back up, what we were waiting on is test data, right? So in order to confirm the importance of the invention, they were waiting on test data that won't be available for, say, another 2 to 3 months. Okay, in this case, since the invention's about 90% complete, the licensing associate will say, okay, let's file the provisional application, and then once we get that test data in 3 months and indeed confirm the importance of the invention, then we'll make the additional expenditure to convert that provisional application to a utility patent application. So this is just another instance where a licensing associate may recommend first filing a provisional patent application. Last bullet, cost. Okay, let's say it's December 2014. The budget is nearly expired for UTRF for that year. Okay, but there's this great idea that comes across the licensing associate's desk. They might say in that instance, okay, since provisional applications are a little cheaper up front to file, let's file the provisional application in December 2014, and then when we get our funding renewed for 2015 and we have a bigger budget allocated, we'll file the utility application at that time. Okay, so this is just a scenario where cost may come into the decision as to whether to file a provisional or a utility patent application. There's also what's called PCT applications. Okay, PCT applications, as with provisional applications being a placeholder for utility applications, think of a PCT application as being a placeholder for filing international applications in several jurisdictions. Okay, so there's receiving organizations throughout the world. Any country that you most likely want to file to has a PCT receiving office. And what you can do is you can file a single application in there, and it will serve for you as a placeholder for later filing international applications in various countries at either 18 months or 30 months after the filing of your PCT application. So let's look at a flow chart that kind of illustrates that. If you see on the left-hand side here, it says the PCT system. In this particular example that's cited, it says file local application. Just for explanatory convenience, let's assume that the local application that was filed in this scenario was a US application. So now you filed a US utility application or provisional application at 0 months. From that point, you have 12 months to file what we call this international placeholder or PCT application. Okay, so once you file that application at 12 months, in this example, you have 30 months to file internationally. And so if you look on the right, that's what we call the national stage applications. So for example, let's say application A would be in Canada, application would be in the European Union, which they have a centralized office. C would be Japan, and D would be China. Okay, so in this example, we filed a utility application at 0 months in the US. We filed a PCT application or the international placeholder application at 12 months. And then 18 months later, we filed what we call national stage applications in the 4 countries I just indicated. Again, that's Canada, EPO or Europe, C would be Japan, and D would be China. Okay, if you filed the PCT application first at 0 months, you would actually not have 18 months to file, but you would have the full 30 months to enter the national phase. So it's really a business decision that licensing associates or in-house counsel or companies make. You can delay this national stage application process by 18 or 30 months. And a lot of that has to do with just cost and budgets. So one thing to remember, though, is just because say the US application issued as a patent in the United States, that doesn't mean you're going to get a patent in these other 4 countries. Each jurisdiction or each country has different sets of rules and laws, and so you could have different outcomes in different countries. So in this particular example that's shown, let's say you were issued a patent in the United States, but then at the national stage application stage, you were issued a patent in country A, which was Canada. Here, country B was Europe. They denied your patent. Country C, you got a patent in Japan. And country D, China, you weren't issued a patent. Many times you would get a patent in all 4 countries. Sometimes you may not get a patent in any of those countries. So it just depends on the situation and the scenario. So that's just a brief overview of the PCT application process. We just talked about this in the last slide. Let me go back because it's probably easier to go this way. If you see just at the top, it says Chapter 1. That's the stage. This is the route that most people follow. You're required to follow it if you don't go to Chapter 2. And what Chapter 2 is an optional stage which costs more money, so most people don't elect to do it. But in Chapter 2 stage, you can get what's called the preliminary examination report from the International Patent Office where the PCT application was filed. But again, it costs more money. More commonly now, I see people just go the Chapter 1 route, whereas you file the PCT application, and then you have 18 or 30 months to file your international applications. Okay, let's talk about the utility patent process. Okay, this is where you, as an inventor in the College of Engineering, fill out a technology disclosure form that's available on UTRF's website or in the office itself. So you fill out this disclosure form, and then it's reviewed by some sort of review board set up by UTRF that could probably comprise, professors, deans, licensing associates, whoever they deem important to the application process. Just go back for the conception of the idea. Never be afraid to fill out one of these forms. I mean, don't think you have a bad idea. As John said earlier, feel free to disclose whatever you have to UTRF and let them make the determination. Okay, I think that it's better to just err on the side that you have a good idea. Most of the time, people coming out of universities and college engineering like this, your idea is worthwhile, and the reason why it wouldn't be pursued by the UTRF isn't because it's not a good idea. It might come down to just cost or budget reasons, but let them make that determination. Don't be afraid to submit an invention disclosure form to UTRF. So once you submit the disclosure form, let's say that it's accepted by UTRF and they want to go forward with it. That's where you go into this patent application preparation process. That's where you work with a patent attorney and they draft the application and then submit it back to you for review. Once everything's finalized on that end, you go into what's called the patent application prosecution process. This is the process between the patent attorney and the USPTO. It's a negotiation to determine whether your invention's patentable and whether the USPTO will grant a patent for your idea. And then hopefully, at the end of the process, you're issued a granted patent. So let's just look a little bit at the technology disclosure form. You fill out this form, and there's some, on the form itself, which we've also provided as a separate handout, they ask for some basic information. They ask for title of the invention, a brief description of the inventor, the brief description of the invention. They also ask you to identify any disclosures up front, and then also some related prior art, such as theses and dissertations. Okay, why do we have identify any disclosure dates? It's exactly what we talked about before with the provisional application. If you have a presentation that you're going to make in 2 weeks, the licensing associate needs to know about that so they can make a determination as to whether they should file a provisional application or a utility application. So that's why they're asking for that information in the form. They only ask for, in UTRF's form, they only ask for a brief description of the invention. As a practical matter, I actually prefer a little more detail that you could attach as, say, a Word document with reference to a couple figures, flowcharts, or drawings. I think this helps streamline the process in the end. It helps the patent attorney understand what your invention is up front, and then there's less interaction between you and them in the process, and less of your time's wasted going back and forth with the patent attorney. Also, the patent attorney spends less time on it, so it reduces cost. The next bullet here is provide a copy of prior art you know of. This is just a duty of disclosure you should be aware of. If you're aware of a patent that is material to patentability or that could preclude you from getting a patent at the patent office, you need to let your licensing associate or the patent attorney know about it. We're not asking that you go search for prior art or search for articles. It's just simply that, if you really know of something, if you know of a piece of art that would preclude patentability because it was so material, we need to know about it. Because ultimately, you just don't want to mislead the patent office or you don't want to lie to the patent office. Why? Because ultimately, if you lie to the patent office or you attempt to hide some sort of reference from them, it can possibly lead to the loss of a patent. Just one note regarding this duty to disclose prior art. It continues not only from the filing of the patent at the USPTO, the patent application at the USPTO, but it comes all the way to issuance of the patent. So it's a continuing duty. So here, initial meeting with the inventors. So once you submit the technology disclosure form, UTRF approves it. The next part in the process is you'll have a half an hour or an hour call between the inventors, the UTRF representative, and a patent attorney, such as someone like myself. What do we do in this call? You just briefly discuss your invention disclosure, make sure everybody's on the same page, that the patent attorney understands your invention. And this is all done before you put pen to paper, before you start drafting the application, because this helps streamline the process. So after that, the patent attorney will draft the patent application and will circulate it to all the inventors for review. So the inventors, you should thoroughly review the application to make sure it's complete, or at least have a lead inventor thoroughly review the application to make sure it's complete. Why? Because once a PCT application or a utility application is filed at the USPTO or with an international receiving office for PCT, you can no longer add any more information to it. You're stuck with what's in the four corners of the documents you submitted at the time of filing. So if we can emphasize anything at all, this is really your chance to review and make sure that the application is complete. The next one, focus on the claims to ensure that the invention is claimed correctly, sufficiently broad. This is really the patent attorney's job, but if you're a sophisticated inventor who's been on several patents or several patent applications, it just may not be a bad idea to look it over. I mean, someone like Mary Koshin, who's been on possibly 7 applications, she may have a good idea. She may be someone who wants to take a look at those claims. If it's your first patent application, it's probably better served to have the patent attorney handle that. But I mean, again, if you're a sophisticated inventor, it may be worthwhile to screen the claims to make sure that they're not easy to design around. What do we mean by that? Let's take a rudimentary example where your patent's directed to a seat portion and you claim 4 legs on there. So the patent attorney specifically puts in the claim a seat portion with 4 legs. Well, that's pretty easy to design around because to avoid the patent, all you would have to do was build a product with a seat portion and 3 legs. So we're looking to avoid stuff like that. The better patent term would be a seat portion with 1 or more legs. So it covers all those scenarios. Okay, so that's a basic example. That's something we're probably not going to see at the college engineering, but it's a scenario like that where a sophisticated inventor may just want to take a look and scan the claims that are in the application. So once that process is done and the patent attorney includes your revisions into the application, it's ready to be finalized and filed at the USPTO. So once the application itself is filed at the USPTO, now we're in what's called the patent prosecution process. And we've provided here a timeline. Typically, from the filing of the application at the USPTO to allowance or issue of patent, usually takes about 2 to 4 years. So you can see here on the left, we filed the utility application. It indicates that you have 12 months to make your foreign filings or file your PCT application. At 18 months, your application publishes unless you submit some sort of petition specifically requesting that it doesn't publish. So even if your application never issues as a patent, it's often published, and it will be publicly available at 18 months following the filing. So you'll be able to look at your patent publication on the USPTO website. Also, Google Patents has a great service where you can go in there and also view patent publications. So how long does it take to get an initial office action from the USPTO? It's typically about 2 years before the patent office acts upon your application and gives you a preliminary finding on patentability. So what happens after that? There's a series of responses between your patent attorney and the United States Patent Office, specifically patent examiners at the United States Patent Office assigned to your case. And there's this back and forth through written responses, negotiation. You may also have a telephonic or personal interview with the examiners in the office. And hopefully, after about 2 or 4 years, there's an agreement that's reached, and the examiner will decide to allow your application. Subsequent to that, then it issues out a patent. Again, there's no set time period, but typically it's 2 to 4 years. There are government costs associated with filing patent applications at the USPTO. The cost of a design application is between about $600 and $700. A utility application, on the other hand, is about $1,600. To file a PCT application, it's about double that. It's about $3,500. So the process isn't cheap. These are just government filing fees. So you can see at the bottom, they don't include the cost of paying a patent attorney for preparing filing and prosecuting the patent application. The good news for an organization such as UTRF, it's included a nonprofit, it's organized under 501c3. What does that mean? It's entitled to 50% discount on USPTO fees. So with the example before where it was $1,600 to file a utility patent application, for UTRF, it's $800. Now there is one caveat to that on the application where Mary Koshin's listed. That was co-assigned to Siemens. That is because Siemens was a licensee on that application. In those instances, UTRF does not qualify as a small entity. They pay full freight, but they're probably not ones footing the bill in that instance. Since Siemens is a licensee, they're driving the prosecution, so they're probably paying for all the international applications as well as all of the US applications and the associated prosecution. So with that said, that concludes our lecture, so we appreciate your attention. And then I can call John up here again if you guys have any questions for us that you'd like us to answer.